All right. All right. Hello, everyone. Slowly from the waiting room, people are joining the main session. And yeah, okay, perfect. So I'm happy to present to you this week's topic and this week's workshop. And we are speaking about rather tough nut, I would say, to crack about legal check and what you need not to forget. Otherwise, you will wake up in the middle of the night and you will not be able to sleep again until the problem is solved. I'm joking, but nevertheless, I'm also happy to present to you Katja Fischer, who will be helping us today with going through some legal bottlenecks and issues for startup. And with this being said, I think I will pass the word to you, Katya. And yeah, I will just let in the latecomers because we're expecting more people to enter the room.
Yeah, sure. So I'm gonna, hold on, let me make sure I can see everybody. Cool. All right. So nice to meet you all. I will give a little background on myself. So my name is Katja Fischer. I'm based in the United States. I am an attorney admitted in New York, Arizona, and United States Tax Court. I've been practicing for over 15 years. I have been a partner in a major law firm. I've had my own law firm. I was head of a technology transactions practice for the law firm. I've worked with startups and founders throughout my career. For the past 6 years, I have been the chief legal officer of the Constructor Group. So I oversee legal for our venture fund, Constructor Capital, our software company, Constructor Technology, for Constructor Knowledge. I also was the managing director of legal and people at Constructor University the first year after we acquired the university, and I led the acquisition of the university on the legal side. And Serge Bell, who I'm guessing all of you are familiar. I don't have to give any background on these companies and who these people are, but stop me if I do. I'm his personal attorney. I oversee everything for his family office and for all of our different businesses. What that means is I've worked in 10 countries, at least, probably more at this point, around the world. I've set up all of these entities everywhere. I've overseen issues ranging from startup investment deals to big private equity exits and closings. I have overseen advice for startups, how to incorporate, get set up, employment issues, intellectual property. I have represented investors on the other side of the deal. So pretty much you name it in this field of entrepreneurship and business and technology. I don't know if I've seen it all, but I'll say I probably have, but I've definitely seen a lot. I have 7 people who report to me in my legal team worldwide. I work with all the big law firms. I like to say that I don't know the answers, but I know the questions. So I'm going to help you today to frame and understand what questions you should be asking. Okay? Can't give legal advice on everything. I'm not giving legal advice on this call at all, but hopefully you'll be able to walk away today understanding, what are the things that you should be thinking about as startup founders and how you should be thinking about it and how you should be prioritizing legal issues, because sometimes it can seem very overwhelming and it's very hard to understand which issues really are pressing for you at this stage and which ones you can kind of put to the side. I'm also the CEO and founder of Aracor, which is a legal technology company. We deal mostly with investment funds and family offices and helping them to really see and understand all of the complex legal documents that they interact with every day, because the amounts just compound with time. If any of you have already been through investment rounds for your companies, or you're familiar with Series A financings, or dealing with different investors on your cap table, etc., you probably already run into this issue that there's so much complexity right? And there's so much to deal with, and the more successful you become, the more the more crap you have, right? And so the issue really becomes that you have these outside law firms that we all have to give so much power away to, and they're great and they're necessary and they're valuable, but at the end of the day, people in their companies, they want to have ownership of their deals. They want to really understand what it is that they're interacting with. Here's a little bit of an about me on the screen. I see we have a few latecomers, so those of you who missed my little speech, you can learn about it here. Yeah, so that's a little bit about me. So now I'm just gonna jump in, okay? So we're gonna talk about the importance of understanding legal issues in startups globally. All of you are from different places. You know, have different stories and all of that. There's no one size fits all for any of you, which is again why it's kind of hard to give very, very specific information on this discussion, but I can definitely frame it for you. And given the fact that I work with so many global companies, I'm very familiar with all of these kind of international trans-border issues. So here's what I'm going to do on this call today, okay? I'm going to walk through each slide, and at the end of each slide, I'll give you guys the opportunity to ask a couple of questions. If those questions are relevant, I'll answer them. If it's something that I already know and might be presenting later in the conversation, I might pause it and just say, hey, let's circle back on that one. But I want this to be interactive. I want you guys to actually pay attention and not fall asleep while I'm talking, because, you know, then why are we here? So, all right. And so what that also means is that if you guys don't ask questions and you're not interactive, I'm just going to start calling on some of you randomly. So be aware. I also used to be a professor of law and technology at a law school, so I'm used to calling on people randomly. All right, so let's get started. Let's talk about business structures and formation. So this is very United States heavy, but I'll translate it for other places. So generally speaking, you have several types of business structures. You have a sole proprietorship. Sole proprietorship is just the least complicated. It's just you came up with a business idea and you didn't incorporate it. You didn't set up anything. You don't have an entity. It's just you, and you're, you know, somehow making money or trying to sell something. And so the benefit of that is, hey, like, you know, doesn't cost you anything, didn't take you any time. You can get to work. There's nothing stopping you, right? The challenge, of course, is that you don't have what's known as limited liability. So the reason that people incorporate is in order to separate the entity from themselves and turn the entity into really like a separate person, so that when the entity has legal issues, liabilities, things like that, you as an individual are kept separate from that, and that's seen as a separate corpus. Then we have partnerships. A general partnership, it's kind of the same thing. It's just now it's two people or more, right? So with partnerships, you can have a business that's, you know, several people, and just like with a sole proprietorship, you don't need to form anything to create one. I mean, you could have a piece of paper just saying that, you know, I don't know, Irina and I are now partners in a new business. The challenge there, again, is unlimited personal liability and personal liability for the decisions of the other partner. So the challenge that you have is all of a sudden you set up a general partnership, you don't have a corporate format, Irina goes ahead and does something very naughty, right? And all of a sudden I'm liable. And so you want to make sure always that when you're doing business deals with other people, with your investors, with your co-founders, et cetera, that, you know, the liability is separate from you. So that's really the concept of why we set up entities to begin with. And then you really have two types of business structures. They have some different names in different countries and slight variations, but you have corporations and you have limited liability companies. And so really for all of you, if you're in tech, we're really going to focus on the corporation. The limited liability company is just generally speaking less relevant, but I'm going to go through it anyway. So just starting with the limited liability company, it's usually not as complex to form as a corporation or complex to maintain, right? It has the ease of operation like a sole proprietorship or partnership in the United States, meaning that the contracts, the way that things are drafted, can kind of be whatever you want. It could be the back of a napkin, and you can still register a limited liability company. Also, the taxation is different. The entity is not taxed. Taxation flows through to the individuals in the US. The drawbacks are that putting things on the back of a napkin is usually not a good idea. So in the United States, most LLCs now follow formats that make them look like they're corporations. So really it becomes more of a tax matter when people are taking a look at LLC versus C Corp. I will tell you that in other countries, like for example, Switzerland, Germany, you have format like the GmbH, which is most similar to the LLC. So you've seen some version of this. The thing is that C Corps, corporations, which would be an AG in Germany, for example, and many other places, right? Those are the ones that can actually go public on a public stock market. So that's why usually in the field of entrepreneurship for technology, because we're always trying to become, multi-billion-dollar unicorns that are gonna change the world, it's the corporation that is the most common format. But for example, in venture funds, you see other types of formations, and that's really just because of the nature of how all of this is structured. Not going to go into this super deeply. I'm just going to say that the key considerations are liability issues, how things are taxed, right? And also, again, in fundraising, how you're able to bring investors in, how your cap table looks, how things are structured. So the classic structure is the one that investors are accustomed to, and
This is
that's why
exactly
we.
what you want to know. Oh,
Sorry, did somebody have a question?
No, it's just we didn't, there
no,
was no muting.
yeah, I was just on
Um,
mute. I'm so
it's
sorry.
okay.
It's okay,
I was
but
too enthusiastic about your content.
I see actually in chat there is a question. So someone asked, if my company is an LLC, can I switch to a corporation in the US? The answer is yes. So in the United States, an LLC can convert to a C Corp at any time, but a C Corp can never convert to an LLC. So a lot of times, if you've started out in the United States with a limited liability company, it's okay, because you can always do the conversion later. If you started out as a C Corp and you want to be an LLC, it's just a little more complicated because you'll have to set up a new company, you'll have to transfer the assets, right? It's a different way of doing things. Where there's a will, there's a way. But still, yes, the answer is that LLCs can always convert to C Corp. LLCs in the United States can also elect to be taxed as C Corps. They can make a C Corp election. So that means that then on the state level, they're seen as limited liability companies, but for federal income tax purposes, they are seen as C Corps. So it can get progressively more complicated as we move forward, but that's a general thing. Next question. If a company has branches in different countries, can the form be different? The answer is yes. Very, very often you end up having, the more successful and bigger your company gets, I promise you, the more complicated your structure becomes. And very, very often you will have some sort of a holding company. You'll have an entity that's based somewhere, which is like the headquarters. And then you have what's known as subsidiaries, right? Or daughter companies, which are based in different jurisdictions around the world. And depending on what's beneficial in that jurisdiction, what the needs are, etc., you might have different formats. You might also have joint ventures that you end up setting up. Or maybe you have some sort of a holding company on top of your holding company for two investor partners to be able to come together and maintain things, right? There's all kinds of different structures that you see all over the world. Any other questions here, or else I'm going to move on to the next slide. Cool. We can always ask more questions at the end. All right, so choosing the right business structure. So again, this is a little bit more of what I was talking about, but I'll just repeat myself again. So you're considering personal liability. I'm assuming all of you have already kind of understood that part. Tax implications. Whatever country you're in, there's different tax implications. The main one basically is, in the US, as I mentioned, flow-through structures, you get taxed personally. A C Corp, a corporation structure, you're not, it's the entity that gets taxed. What that means is that there is double taxation. And you have that in other countries as well. Don't be scared of it, just be aware. And so why is this important? What is double taxation? What double taxation means, okay, is that when your corporation makes a profit, it gets taxed. And then when any distributions are made to the shareholders, those shareholders are also taxed individually. So when people hear that, they're like, oh my gosh, I'm getting taxed twice, this is crazy. Here's the thing. When was the last time you heard about a tech company being profitable? Right? As a startup, I guarantee you it's not going to happen anytime soon. And I don't think it's even happened yet for Amazon. So it's a wonderful problem to have. And the day that you have that problem and you want to start figuring out how to do amazing tax structuring, by that point, I promise you it'll be much, much later on. And it's not something to worry about. Because when money comes into the company, usually you're then using it for expansion. So I don't mean that it's not revenue that isn't coming in, that the company isn't making money, but usually you're then taking that money and using it to hire more people, right? To open an office in a new location, marketing, business development, et cetera. You're growing the value of your company, and in tech, it's generally the overall value of the company that's seen as more relevant than profitability. Although revenue is very important. Obviously, you want to have revenues, okay? If you are the type of company that's not looking for growth because you're not looking for, let's say, investors or acquisition, right? You just want to be a company that just makes money and provides for you and your family, then revenue profitability becomes a different situation. So usually when we talk about people who own, like, I don't know, a restaurant, right? They might have a very, very different view of how they want to extract value from their company. For them, it might be about profitability as opposed to value generation, even in the early years. But again, I'm just assuming for all of you, you're in a tech incubator, all of that, probably it's about value creation. And therefore, any money that's coming in is instantly getting moved out to continue to expand on things. And then in terms of distributions and things like that, that'll come later. And obviously that's separate from salary. But these are just things that, we think about. So again, these are like questions to ask, things to know exist out there when we talk about it. So again, investment needs. The last is control and management. So with business structures, right, there's certain forms and ways that these companies are controlled. So with corporations, you usually have shareholders, you have a board of directors, you have executives. In a limited liability company in the United States, as I mentioned, you can have various types of formats, although honestly speaking, most of the time they follow the same format as this, right? Where you have, it's just different terminology. So let's move on to the next page. All right, now let's talk about business names and trademarks, okay? So selecting your business name and trademarking the name. I have a question for some of you. Who has actually registered a trademark for their company name so far? Anybody?
We registered a trademark for our company.
Cool. Where did you register it?
Sorry, I will open camera. Okay, so first of all, we wanted to register it internationally, but actually it has several steps. First of all, we needed to register this in our country so that they can apply outside. But honestly, this process lasted like almost 18 months. It was super, super long. And now we got it. Just like a month ago, we have been informed that it is completed. We got everything related to that. But currently, we are thinking whether to continue with registrations. Why? Because it's very expensive. It's much more expensive than I thought. Initially, we had the idea to register it in European Union, United States, in Canada, in many countries. But now we have to really focus where we really want to go, because at this point of time for us, this is huge investment.
So thank you so much for giving all that insight, because you just touched upon so many things that I wanted to discuss right now. So it's really great to hear about it from a founder's perspective. So basically, let's just start with what is a trademark, okay? And then I'll work backwards, because we're all sort of assuming that everybody knows what that means. A trademark is the word or term that identifies your brand. It's your unique identifier, okay? So like Google, right? Constructor, etc. It's become more and more difficult, frankly, to find a really great unique identifier, because there's so many brands, so many companies, so many things all over the world these days. But creating that unique brand identifier has a lot of important value, because that's how people remember you. That's how people remember your brand. And it's not always just, by the way, a name. It can be a certain logo, right? So like the Nike swoosh, for example, that's a classic one, right? The Apple. Those things are all trademarks. So it means that once they have the trademark, other companies, other entities, other people cannot go ahead and use those trademarks for business. So they own it, they have ownership of it, they can assert ownership. And there's a lot of value as that continues, because it's for branding, marketing, for people to understand who you are and what you do. And obviously the more successful the company becomes, the more value is associated with that trademark. And so just a second, I see transfer IP before and after. Let's wait on that one, Ali. I will talk about transferring IP, but it's a little bit different, okay? So let's hold on to that comment, and I'll get back to it. So with regard to trademarks, right? This is just talking about your brand identifier. So the first thing you really want to do is, before we talk about trademark registration, is just how do you come up with your brand name and what to look for? So you want to do several things. First of all, honestly, guys, good old-fashioned Google. Just Google the name that you want to use for your company, right? Look it up, look up variations that are spelled differently but sound the same, right? It's not just about owning the .com, or these days it's like .ai. You want to just take a look at everything and see what's out there. It's also possible to do an actual trademark search with different registries around the world. You just have to learn how to do it, or you have to hire an attorney to do it for you, to see if there are other marks out there that have already registered. But you definitely want to take a little bit of time to look and make sure that the name that you've come up with is truly unique. Now, what do I mean by unique? So let's take a look and think about Flourish, for example. I'm going to make a guess that there are other companies on the planet that are called Flourish. It's just a wild guess, right? But it's a common enough term that I would assume it's the case. The thing about trademarks is that if there is a company called Flourish that, let's say, is it Yasna or Jasna?
This is Jasna. Yes, and there are a
Yasna.
lot of companies called Jasna. There are a lot of companies called Flourish.
Of course. So
Yes.
Yasna, here's my question. What does your company do?
Our company is developing educational software. Basically, what we protected, it was like a name plus graphical logo. This is like a package together. Like what you see now on my screen. So that's
cool. So here's the point. If I have a coffee shop called Flourish that's operating out of Venezuela, right? We're not going to have a trademark infringement issue, because first of all, it's going to be a jurisdictional difference. Remember, Yasna was talking before about how she tried to register in multiple countries. And in addition to that, I'm in a completely different category of goods and services. So if you find that there's a company out there that has your brand name that's not really competitive to what you do, if it's in a completely different category, right? Like it's in fashion and you're in med tech or something like that, you don't have to worry about it too much. But if it's another tech startup company and you're in AI and it's also an AI, it might become a little bit closer, and then you need to do formal trademark registry searches. But again, start with Google, take a look around, see what's out there. Domain availability is very helpful, right? It's important as well. And then comes the trademark search. In terms of registration, so from a common law perspective, you actually have certain rights in your trademark just by using it, at least in certain jurisdictions. But that's not the case in all jurisdictions around the world. You do have some rights, but registration does several things. First of all, usually it gives you the right to sue in federal courts. It gives you the ability to sue for statutory damages in the United States. What are statutory damages? That means you don't have to necessarily prove actual damages. You don't have to show that because, this other company called Flourish in EdTech started, this is exactly how much money we've lost, right? Instead, it's just a certain amount that the court will award. It will give you the ability to show that other companies were on notice. They had the ability to find out that you exist because they could have done that trademark search themselves. So trademark registration is important. It's important to protect the brand identity. But as Yasna mentioned earlier, it can get expensive for an early stage startup, especially when you're trying to trademark in multiple countries around the world. So you really want to start with the jurisdiction where you're doing the most business and you have the most activity and it's most important to you. That may be your home country or the country where, the company is registered, or maybe it's a different jurisdiction because that's where most of your customer base is, or your expected customer base. Once you register in one jurisdiction, it becomes much easier to register in others and other countries around the world. But again, it just becomes a cost-benefit analysis of how much money and time you should be spending on registration. There are lots of lawyers out there who deal with trademark registration. Generally speaking, for a startup, it's a considerable cost, but you can usually find them not for too much money. It's not very difficult. But I would just say that before you even hire a lawyer, because think about it this way, a trademark lawyer is always going to be incentivized to tell you to trademark everything, right? Because that's how they make money. So you come up with an idea for a name, they're going to be like, yeah, of course, like, here, give me $1,000. Think first, do your own research, take a look, see, do you really love the name? If you really love the name, then go talk to a lawyer and have them do a professional search for you, right? Or if you've already been using the name. Any questions on trademarks? Or I'm going to continue. And again, the IP question from earlier, I'm going to save that for a little bit down the road. Okay, let's continue. So now we're going to get into more formal IP. So I'm going to give you guys a crash course in intellectual property, okay? Who knows what these things are? Patents, trademarks, copyrights, trade secrets. Good, okay, cool, then I feel smart. All right, so let me explain all of you what kinds of IP you have in your startup, all right? And how to understand how to kind of, piece these things together. There are 4 kinds of IP, more or less. Not more or less, there's 4 kinds of IP. There's patents, trademarks, copyrights, trade secrets, okay? Trademarks we've already learned about. Trademark is what identifies your brand. It's the Nike swoosh, it's the name Nike, it's Google, it's Apple, etc. It's also sometimes called a service mark if you have a services business. It can also be like beyond being a logo or a name, it could be like a phrase. Just do it, Nike, right? Etc. That's what a trademark is. You can register it one country at a time. It's not super expensive, but it is a cost, and it's not just having the domain name ownership or something like that. You want to actually go ahead and have that registration if that is important to you to use that as your brand identifier, because as you grow your company, you want people to not get confused in the marketplace. You don't want copycats to spring up. You want people to start to really associate with your brand, and brand identity means a lot as you continue to grow. Copyright. A copyright is any expression of an idea. So what that means is if you have an idea in your head, you don't own IP to anything. Ideas are just ideas. But when you express the idea, you might be able to assert ownership. So copyright usually is more relevant to artistic works. So I would say it's for things like if I make a painting, if I write a novel, a screenplay, the lyrics to a song, the recording of a song, a television show, etc. Those things are all things that fall under copyright. Copyright also extends to software code. So software code itself may be copyrighted. And also certain materials that you might have within your company. The issue with software code and materials in your company is software code very often these days, it becomes obsolete very fast. So even going ahead and getting registrations of copyright for a certain software code may or may not have value, but you can do it and you can register copyrights on software. The value of copyright on software is as follows. People don't think about this a lot. People pay a lot of attention to patents. Patents are fairly expensive to obtain, but actually, if you drop your software with, for example, the US Copyright Office, it's relatively inexpensive. Like, I don't remember how much the copyright fee is these days because I haven't done it in a long time. It used to be $50. Now I can't imagine it's more than $100, right? And so you want to have an attorney, unless you're very studious and can figure out how to do these types of things yourself. But you can go ahead and you can file copyrights on software, which is just a little extra added protection. Copyright registration has benefits that are very similar to trademark registration, in that, you know, it gives you the right to sue in certain courts. In the United States, you wouldn't have to prove actual damages. It puts other parties on notice that you own the copyright. One thing that copyright has that's cool compared to trademarks is that if you register the copyright in one jurisdiction, all the other countries that are parties to what's called the Berne Convention, which is like a big international treaty that involves pretty much every country except like Brazil and China, you will have certain copyright rights in those other jurisdictions as well. So it's something to look at. Again, generally speaking, somewhat less relevant for tech, but it's an interesting thing to think about. Then is patents. Patents are usually more relevant for tech companies. So patents are your inventions. Patents can be, you know, I'm sure you've heard of patents in anything from physical inventions to drugs, biotech, right? Certain technological advances, certain ways that you may be doing things within your company. Patents are an area that are much more complex than these others. For these, you actually need specialized patent lawyers, people who have background degrees in engineering or in these areas. In the United States, you can't even be registered as a patent attorney unless you have certain type of undergraduate degrees, so that you have the scientific background to be able to really understand the patent. And so for that, you definitely want to pay attention and work with serious lawyers. Patents have a short lifespan, so you don't have the rights to a patent forever. You have the rights to copyright or trademark. You can maintain for many years. I mean, trademarks you can retain forever for as long as your company is in existence. Copyright, it's not forever, but it's past your lifetime. So, but the thing is that patents have a short lifespan, and the trade-off with a patent is when you file a patent, you've made the information behind your design public so that other people can see the patent, understand the patent, right? And then the idea is it's a trade-off that eventually, when your patent is no longer something that you can own and register, it becomes free to the public. In the world of tech, it doesn't really matter, because anything you build today, guys, like in 2 years is going to be semi-obsolete, right? Because that's how fast software works. So the fact that your patent isn't forever isn't something that you should be worried about. Now let me take a look in, Yes. All right. I'm going to answer all these questions. Let me go through trade secrets and then I'll answer the questions. Okay. So trade secret is actually my favorite kind of IP. So trade secret, guys, is not something that you register. It's just something that you keep a secret. So when you have confidentiality agreements, non-disclosure agreements, right? When you're very strict about who has access to certain things, in a way, that's kind of the safest way to maintain ownership over certain things that are very, very valuable. The best example of a trade secret that I can think of in the world is the recipe for Coca-Cola. So recipes, you can't register, there's no copyright for a recipe, right? There's no trademark, there's no patent. There's no way to formally register and protect a recipe. So the makers of Coca-Cola, they only allow a very small handful of people to know the recipe. They're under very strict non-disclosure agreements. And that way it's lasted for as long as Coca-Cola has lasted. Trade secrets can last forever as long as people keep it a secret. There was even a story about a lady who worked at Coca-Cola and she called Pepsi, their executives. It's a real story. And she said, I know the recipe for Coca-Cola and I'll give it to you if you pay me like $1 million. And Pepsi understood like this is not an issue that they want to get embroiled in. They called the police and this woman ended up getting arrested. So, you know, trade secrets are a big thing in all companies. That's why you always have people in your company sign non-disclosure agreements, confidentiality, etc. Because imagine it's like your future plans, your business plans, your strategy, your ideas, etc. Some of these things you don't need to keep so close to your heart, right? Some things it's okay to share them with the world or with certain people, but certain things, if you really need to keep them a secret, just keep them a secret. So that is a little bit on that. Let's take a look on the questions. Okay, how to transfer IP before and after registering and what can be done if a team member leaves while refusing transferring their IP. Okay, so when you transfer IP, after you register your entity, the question is, what is the IP that you want to transfer? So if the IP is just, I'm going to give some easy examples. I'm an engineer. Now I started a startup and I built a bunch of things before I started the company. But now it's like I want to have a formal company based on what I engineered. I will go ahead and there's an IP transfer agreement that I would sign, assigning all the rights into my inventions to the company in exchange for, let's say, shares in the company. That's a classic IP transfer agreement. If I've already registered the IP, let's say with trademark office, patent office, etc., not only do I go ahead and do this contractual agreement where I do an IP transfer into the company, but also I have to go back to that registry and notify the registry of the transfer so that the registration shows the new ownership record. It's fairly easy to do. It's not super complicated, but it's something that you would normally hire a professional for. Okay? If a team member leaves while refusing transferring their IP, so here's the thing, guys, when you hire people, and we'll go into this with employment agreements, when you hire people into your company, make sure that they're signing documents saying that all the IP that they're creating for this company belongs to the company. If you have a team member who's leaving your company and refusing to transfer their IP, you already screwed up. Because why was this team member working in the company, right? Building things for your company and having any kind of claim to any ownership. You need to set those things and set those standards on day one. You work in this company, the IP belongs to the company, right? Now, different IP transfer agreements, employment agreements, they can be broad or they can be narrow. And what I mean by that is some companies will say, for example, any inventions that you create in any capacity whatsoever, when you're at work or when you're not at work on your own free time, while you work for this company, belongs to the company. And that's a way to be really strict, really specific, to make sure if people are doing things, you know, on their home computer and this, that, and the other, that could eventually be competitive to the main business or what have you, it belongs to the main business. Some companies, they will do carve-outs. They'll say, okay, if you have a side project or if you have something that you've been working on for a long time and you don't want the company to own it, you have to list it and you have to write it out and be clear, and we will approve it. I think personally that's the best way to go, right? Let's just be transparent. There's something that you don't want to give to the company? Okay, let's talk about it. You have a, side company that's been doing things that have nothing to do with my business for years, no problem. Let's just be transparent and clear. Some companies will simply say the IP that you're creating specific to this business while you're at work, blah, blah, blah. They'll be very, very specific. To me, the challenge of that is in this day and age, we're all like remote workers. So it's not the same that it used to be, that sort of you come to the office and you work from 9 to 5 and that's what you do. And then you go home and you leave your computer at the office. So I'm always a little bit more concerned about that. I think it's better to keep the interests in the company and just create carve-outs if there's anything. How to prove copyright. If it's just an ideas expressed in meetings, for example, no, that's not counted. So ideas are meaningless and worthless. Guys, they're worthless from a business perspective, right? They're worthless from an IP perspective. Ideas are just ideas. If you want to have a copyright to something, you need to make something, right? You need to code the software, you need to draft the book, right? You need to take action. Next, it's very difficult to obtain a patent for a non-physical thing like AI models. Which jurisdiction is the best in this regard? I have no idea. I'm not a patent attorney. I don't know anything about shopping for where to obtain a patent. I wouldn't really worry about that. I mean, I think part of the reason why it's difficult to obtain a patent is because when it comes to AI and things like that, like there's very little these days that's really unique. And there's really no moat around AI. And so one of the things you have to remember with IP is just one of your strategies as business founders, right? It's just one. It's like an arsenal of different strategies. Because what are we really trying to do? You're trying to create value and be successful and beat competition, right? IP is one of those things. In AI, your moat is your customers. Your moat is your way of doing things. Your moat is, the way that you do marketing and development and unique ways of serving customers and things like that. You're not gonna be able to build a strong moat in the world of AI these days, with tech and patents and things like that. And the other thing is, even if you do register patents, like what are you gonna do with those patents? What are you gonna do? You're not gonna go around suing everybody. You're gonna have a very hard time suing people and showing that they really infringed on your patent because everybody's working in AI, right? So the point of when you spend money on all this IP registration, think about what's the ROI on it, right? And so with patents, that's why I said, like, you want a really good patent specialist and you want to be really hyper aware of what's the value. Are you going to license your patent to third parties? Then there may be some value, right? Things like that. Trademark, it's a little bit different because if you come up with a business, let's say Yasna, built Flourish, and flourish.com was already taken by somebody, and so she did like flourish.co, and now she spends all this money on branding, ad campaign, social media, like this, that, and the other, and then she gets a cease and desist letter from another company called Flourish saying you need to change your name. If it's an early stage company, it's annoying, right? But if it's later in the stage of your business, it can actually be damaging because now your customer base, people out there, they've come to associate the name with you. So, but these things happen. I mean, you have stories of like, there are rappers who had to change their names because in other countries there were like other companies that were using those rappers' names, and so I mean it gets complex. If IP is limited to code, for example, if the code of the leaving member is recreated legally, the IP transfer problem could be solved. I mean, not if you're copying the code, right? Like, who owned the code to begin with? So, I mean, just because you copy somebody else doesn't solve a problem. The point is that if the person works in the startup and created IP, who owns it? Did the company own it, or did that person own it, right? You could recreate the code if that person left the company and, let's say, deleted the code and they've been obnoxious about it, but that's not the same thing as ownership. So the first thing you need to do is determine who owns that code, right? If there was no contract or anything, arguably, I would still take the position that the company owns the code, right? But that's an arguable point, and that's when lawyers get involved. Okay, our business model has both a, but we already have, I have no idea. So when it comes to things like genomic discovery and other scientific things, guys, go talk to a patent lawyer specialist. Patent lawyers can always advise whether registering a copyright has any value. The point is, I'm just teaching you the questions to ask, that you can always ask that and see what they say. Let's move on. Employment law. All right, so this is for the guy who decided to have a partner in his company who didn't assign over their IP. So, all right, let's talk a little bit about your employees. So you have employment agreements. You always want to have everything written down and in paper and contractual. There are employment laws and rules in every country around the world. A lot of them are somewhat similar, but there are things that you really have to take into consideration. So, there's all kinds of anti-discrimination laws and fair labor standards, etc., and different regulations that you need to think about. And here are some of the biggest challenges. So the number one biggest one with every startup is, this is my favorite, this is the employee versus the independent contractor, or employee versus consultant, okay? Oh, I'm not hiring this person as an employee. I'm not going to put them on payroll. I'm not going to have to spend all that extra money on taxes and all this stuff. He's an independent contractor. It's fine, okay? Independent contractor is not what you decide it is. Independent contractor is subject to several things. Number one is an independent contractor is somebody who is in business for him or herself, okay? And so what that means is that that person, first of all, in many countries has an independent contractor registration. In Switzerland, Germany, most European countries, most Eastern European countries as well, there's a rule that they have to register as an independent entrepreneur or independent contractor. So you always want to have evidence of that. In the United States, you don't have that rule. You don't have to be registered. Although obviously if somebody registered an entity like an LLC for their business, it makes it more obvious. The independent contractors are in business for themselves. That means the hours, the rates, the way they do business, and most importantly, the ability to go and work with other clients and customers is, the nature there. An employee is somebody who is on salary, on payroll. You as the employer are really controlling the nature of their business. You can say you cannot work for other companies while you work for me. Right? You might want to instill certain non-compete terms if they leave the company, which may or may not be enforceable. That's a different discussion, right? It's the ability to, have them be totally part of the company and restrict them in certain ways. Misclassification, if you hire people as contractors who really should be employees, you risk going and being subjected to audits and penalties and back taxes. And certainly in countries like Germany, for example, there's, you want to be very, very careful and very mindful about that. So the first thing to just remember, independent contractor is in business for himself or herself. Employee works for your company. So also independent contractor, right? There are things that they can do. Like you have independent contractors who are registered and all that, and they might, use your company email address or something like that because it creates ease of use, but you still want to have some record that they're in business for themselves. So it gets a little bit more complex. I'm giving you kind of just the rough nature of thinking about these things and the context of who works for you, right? Okay, next. Contracts and agreements. So now let's talk about not just with regard to employees. And by the way, with employees, the other thing I want to talk about is, again, you want them to sign confidentiality agreements. You want them to assign their IP, right? You might want to have other terms like non-solicitation of customers, non-solicitation of employees, meaning if they leave your company, they can't take half your team with them. things like that. Those are the types of things to look for in contracts. Another thing is KPIs, key performance indicators. You really want to track your employees and be able to really transparently and openly measure what success looks like. It's really important, not just from a legal perspective, but like also just from a, being a good boss, right? You want to be able to make sure that people understand what it is that's expected of them, how to meet certain things, and if they're not doing, the best, how to get there and how to work with them. It's also important from a legal perspective because you need to create as much of a record as possible. If you had to give written warnings to somebody because they didn't, I don't know, show up to meetings several times in a row, things like this, so that if you do choose to terminate, especially after trial periods, you will have a much stronger case. What happens very frequently, like for example, in Germany, you can have a trial period for up to 6 months. Other places, there are different terms, or it can be contractual as well. But like the maximum in Germany is 6 months. But after that, if you were to want to let somebody go because they're not performing well, you'd better have a really, really good record, right? That you worked with them, that you tried, that you gave warnings, etc., so that it's all there. Okay, so now let's go to contracts and agreements. Let's talk about the essentials. Any questions, by the way, on employees before I move on? Let me see. There's no questions. Fabulous. Okay. How much time do we have, by the way, Irina?
So we have more or less half an hour plus
Okay.
7 minutes. So like 30, 40 minutes. Yeah.
Okay, perfect. Just making sure. Thank you. All right, so equity and ownership. All right, so equity distribution, right? And wait, no, I went back. Sorry. Hold on, I skipped one. Let's go back. Contracts and agreements. Okay, so here are the essential contracts. First of all, it's the founders. Do any of you have co-founders, or are you all solo founders? Who has a co-founder? None of you have a co-founder? That's great. You don't have to fight with anybody. All right, we've got one at least. I have another thumbs up. We got two. You guys are so shy. Speak up. All right, we have some more. Yes, I have, we have. All right, cool. So a bunch of you have founders. So the first thing is you need to have a really, really good agreement in writing with your co-founders. Because I guarantee you one day, I'm really sorry to say this, just in my experience, I have no scientific evidence behind this. I just have like many years of experience. The person that you're going to end up in a legal battle with, number one, is going to be your co-founder. I don't care if the person's your best friend, your spouse, okay, your sibling, like whatever. You guys are two peas in a pod, you love each other, you work so well together, you never need anything to come between. That's the first person you're going to end up fighting with when your company is successful, I guarantee it. Or when your company is not successful, right? So you need to make sure that you guys are super, super clear. And one of the things that irks me, right, that like it drives me crazy is people feel really this like discomfort with contracts. Like contracts are bad, right? I've always seen this psychological thing that people are like, no, we're partners, but like we're best friends and we're so cool. We don't need to spend too much time on this. We don't really even need the agreement. Yes, you do. Okay? Yes, you do. Believe me, it's so much better to have an agreement that's super transparent, super clear, covers the bases, makes sure that there's transparency, that whenever there's a tension between you and your partners, actually, it will make less tension. I guarantee it will make your relationship better and stronger and healthier and happier to have a lot of things clarified up front. Because otherwise, if you're like, oh, we're 50-50, okay, well, what happens when you're 50-50 and let's say one of you is really doing all the work and the other one doesn't seem to be pulling her weight, and then 6 months later, she also decides to leave the company and you've now lost 50% of the company, right? What happens? Like, have you thought of those things? You need to make sure that with founders, first of all, that their equity vests over time, yours as well, to show commitment to the company, right? So that your ownership is split up, right? So that there's founder shares that are vesting. You need to understand what people's responsibilities are. You need to understand what their responsibilities are in terms of equity, in terms of, if in addition to that, they're taking on like a passive role, an active role, who are they going to be? Am I going to run chief marketing officer? Am I just this or that? All these things need to be determined and figured out. And it's really important. And actually, if you're trying to think like, where should you spend some money with an attorney and take a little bit of time, I would point to that. Because if as your company grows, that'll be the number one source of tension. And investors will want to understand and see and all of that as well. Non-disclosure agreements. I talked about this earlier. This just means, keep things confidential and under wraps. Make sure everyone's signing NDAs. Here's the thing about NDAs. NDAs, nobody ever litigates over NDAs. Nobody ever goes to court over NDAs. NDAs are basically like handshakes in this day and age. But do the handshake because it's psychological in addition to everything else. It's creating that sense of respect. Like if a venture capitalist wants to come in and learn more about your company and see your data room, that's okay. Sign this NDA, please, right? If you have a new employee coming into the business who's going to learn a lot of stuff, that's fine. Sign the NDA. Some venture capitalists, by the way, they won't sign NDAs for first discussions. That's industry standard. It just depends, but you can always ask them to. And before they get into your data room and start seeing like financials and things like that, then they definitely should. But like first initial discussions, looking at your pitch deck, they might not. But the point is that NDAs, it's a handshake that you want to have. Service agreements, sales contracts. So service agreements, right? Any third-party service provider, independent contractors, their agreements, right? Agreements with any company that you're working with. If you have like third-party providers, if you're working with, I don't know, Amazon Web Services, right? Or Microsoft, things like that. Those service agreements matter. You have to pay attention to them. You have to understand the terms and conditions and payment terms and termination clauses and what they actually mean. That's, by the way, what my software does, helps go through all of those things. But, you want to get familiar with that stuff yourselves to be able to understand what it is that you're negotiating. Don't put too much in the hands of lawyers, but do use lawyers as well to help you. So usually, with the service agreement and all of that, if you hire a good lawyer, they'll create some sort of a standard template or standards that you want to look at to understand what you're getting when you negotiate these agreements with third parties. Sales contracts, that's with your customers, right? Those are usually your standards as well. You can take a look at industry standards. You can take a look at sales contracts of your competitors to understand, and you can work with an attorney as well to understand sort of what are the rights and what are the terms and what are things that you should pay attention to. But you definitely want to pay attention to these things, right? Because a lot of times, like with service agreements and sales contracts, like little things that come up, I don't know, off the top of my head with service agreements, people always forget, they'll sign not realizing that there was like an automatic renewal clause. And then they stop using that service and then they get a giant bill for the following year. And they're like, wait, I don't want to work with you anymore. And the person's like, haha, this was auto renewal, right? So little things like that, you definitely want to pay attention and understand what you're signing. So I would say that those are the essentials. Let me go and look at the chat and see, because I think we had some questions. Hold on a second. Yeah, let me take a look at the chat before I keep going down. What's your opinion on platform like Clerky with standard docs? Yeah, guys, standard docs are fine. Look, here's the thing. Here's my opinion about standards and AI and this, that, and the other. They're great. They help and they get you very, very far. I still highly recommend that you definitely want to hire yourselves an attorney. It just, the more you can educate yourselves, the less you will need to pay that attorney and the more control you will have. But always have a real professional come in and check things, especially once you start fundraising and working with outside investors. It becomes really, really important to make sure that you have good representation, right? And so, but using Clerky, using, Carta, all of that stuff, like, yeah, absolutely, go for it. There's a lot of stuff here that just the industry has become so standardized that you'll be in great shape if you're using those standards. So, all right, let's continue on. Okay, equity and ownership. right? So founder shares, stock options, cap table management. So founder shares, that's what I was talking about earlier with regard to vesting periods, ownership, things like that. You bring in a co-founder, you want to make sure that that co-founder is going to like stay with you and deliver, right? Because you give somebody a big piece of equity in your company and then they quit the next day and you're like, oops, right? So take a look at vesting schedules, learn about those, how those shares work. Again, this gets into a much more sort of complex area of law where you really start working with more serious attorneys to understand things like stock options, et cetera. But I'll explain to you guys just a little bit like what is a stock option. So one of the issues that you have in granting equity is this. On day one, right, Irina and I, we started our company together. Maybe we decide we're 50-50 from day one because Irina's bringing, I don't know, the customer base and the branding, and I'm bringing the IP. And so we decide we're just going to be 50-50, and then we come up with other strategies, how we're going to stay part of the company, how we're going to be able to give it, you know, to move on, et cetera. Maybe we have a reverse vesting schedule. Who knows? There's a lot of discussion. But now we have the next thing, which is now our company, we've put money in it, we've raised, we hired employees, and the employees are like, hey, we want a piece of this company too. Very, very natural, right? And we want to incentivize those employees to stay with the company, to help us build something very valuable. Or like, we're building a $10 billion company here, you know, you stick with us, I'm going to give you, I don't know, 1% of the company in exchange for being the chief marketing officer, right? So here is the issue. Let's say our company is already worth on that date $10 million because we've raised capital, we have some customers, et cetera. If we give 1% to the chief marketing officer on day one, she's going to have a taxable event immediately. So the tax authorities are going to be like, oh, you got 1% of $10 million, now pay taxes. But the chief marketing officer is going to say, but I didn't get any cash, right? This isn't liquid, like there's nothing I can do with this. So that's why we've come up with all these strategies. They're all tax-based, either to have stock options or to have what's known as restricted stock units. Stock options is basically I give, instead of 1% of the company, we give the CMO the right to buy 1% of the company at the $10 million valuation, but she doesn't have to exercise that right until the company is worth like $10 billion. So she could wait until the company is worth $10 billion, it's going through a big exit transaction, and on the same day she exercises at the $10 million valuation, she sells that stock at the $10 billion valuation, and she doesn't care about the tax she just paid because she just made a lot of money. So that's what stock options are, if any of you were ever curious. Restricted stock units, it's actually grants of the actual stock, but it just happens over time. So the big thing is with vesting periods. So what vesting means, assuming you guys know this, but if you don't, it just means a period of time over which people get the benefit of either the stock options or the restricted stock units. And that's just a way to ensure that somebody doesn't get a big benefit and then quit the next day, or you decide that you don't want to work with that person the next day. It's to keep them motivated, keep them incentivized, keep them working for the company, but simultaneously also give some power back to the company that if they decide to let that person go, they're not giving away a big chunk. Cap table management, keeping track of equity allocation. So then what basically happens is now you have all of these employees who all have stock options, a traditional stock option pool. So those of you know, usually you set aside about 10% of the company for stock options. Sometimes it's more, it can be 15%. I've even seen up to 20%. Sometimes it's less. 10% is usually the standard. And so basically out of the whole pie of the company, 10% is going to go to these employees. That might change with later rounds as you go, you know, and you grow the company and so forth. But think about it that way so that when you're giving away stock options or restricted stock to employees, you're figuring out what the incentive should be. You create a pool, and then you have to think about the employees you have now and then how big your company is going to become over time. But again, the employees who start very early stage, they are taking on much bigger risk than employees who come later. So if I give 1% to my CMO when the company is worth $10 million, years later, I might give 0.1%, right, to somebody who comes and works in the marketing team, but the company is now worth $10 billion. So that's how it works. So you need to keep track of all these things. You have to keep track of all your investors, equity allocation, et cetera. There are companies that do that, like Carta, where there's just software that can do cap table management for you. But it's something to keep in mind. Okay, I'm gonna move on. Any questions so far? Just gonna stop for a second. We're good? All right, cool. Data privacy and protection. So data privacy laws in the United States, there's no real like federal regulation on privacy. It's all state by state, incredibly annoying. But in Europe, we have GDPR, and GDPR rules everything. Pratik, you have a question?
Yes. Yeah, I have a question. And do employee stock options also carry voting rights? Or, in our firm, we are also giving advisory stock to key opinion leaders who are coming over there.
So here's the deal. You don't want it to, okay? But it's a great question. So in the United States, for example, normally you would never give voting rights with the ESOP plan because it's tedious. Think about it. You end up like if you end up with a 1,000-person company and all these people have to vote on stuff, it's like ay, right? So usually it's just common stock. But I will tell you that, for example, in Switzerland, right, the second they convert the option into stock and they join the cap table, they automatically get certain rights. But usually those employees, they don't convert the option to stock because then they would have to pay money. So they usually wait for an exit anyway. So it's okay. But anyway, the point is normally you wouldn't do that. You wouldn't give like any kind of preferred share or anything like that. It would just be common shares, and they would have very, very standard like tag along, drag along rights, things like that. But you want to restrict the rights as much as possible, just because it becomes overly difficult. You don't want to have a situation where every quarter you have to answer to so many people. I hope that answers it. I see something.
Yeah, it does. Thank you. Yeah, it does.
Yeah, absolutely. Cool. Okay. So data privacy. So yes, as I was saying, so GDPR changed the landscape, okay? Because before GDPR and all these regulations and everything, it was really fun. Like the world was able to get everyone's data and sell the data and, manipulate the data. And now we have all these regulations. And GDPR is really for the European Union, but it affects everybody everywhere because we work in an international landscape. So the thing is, you have certain data protection laws, like in California, you have very strict laws. There's strict laws in other places. Honestly, if you understand GDPR, there's nothing stricter than GDPR. So it's like if you meet GDPR standards, you're going to be fine. The big things that you have to remember, like big ticket items, okay, with regard to privacy, is you need to have a good privacy policy. You need to be very, very clear about privacy. It's very good to have opt-in language and check the box for everything, right? All the standards that you've seen, obviously, as you all see when you go to different websites, you have the accept cookies, right? All of these things. It's all about transparency and clarity and the ability to opt in, and especially under GDPR, the ability to opt out, right? And the right to be forgotten and the ability to remove data. So if you're collecting data, even like on your employees, right, customers, et cetera, you need to understand where are you storing that data, who has access to that data, and if somebody wants their data removed, do you have a process in place to delete and clean all that data? So you just need to be mindful of data processes, and you need to just understand the basics on this. Depends obviously on the industry that you're in. If any of you are like in healthcare, your data privacy issues are going to be through the roof, right? In the United States, there's HIPAA regulations, and like that's a whole other set of things to consider when it comes to data privacy. But kind of like the basics is just, pay attention, what's your data privacy policy, and make sure your engineering team follows the policy. I've had challenges before where I've seen situations where you'll have somebody who's like a privacy officer or a lawyer who drafts this amazing data privacy policy. This is how we handle the data, and this is where we store the data, and blah, blah, blah. But the engineers don't actually follow it. So it's like really funny, right? And so pay attention to it. Make sure you have a good policy in place. Make sure you're staying up to date. There's the EU AI Act now as well, which I don't think is the bigger challenges are really going to relate to most of you, but those of you, if you're dealing with AI in education, it sort of relates. If you start getting into deeper stuff like healthcare, et cetera, then data privacy becomes one of your primary main concerns. So again, not giving you guys that much information here, just saying that these are things that you need to think about and understand and pay attention to as you build this out, because it'll come back to bite you. Regulatory compliance. Again, this is just general stuff. It really depends on the industry that you're in. So these are all industry specific regulations, and whether or not you need certain licenses, certain permits, things that are specific in certain countries, et cetera. Usually healthcare and financial services are like the two big ones where stuff comes up. I'm not a super expert for healthcare. I'll say that with healthcare, like, again, the data privacy stuff is a really, really big one. And then there's other things. Financial services, it's another one. Just really common stuff. If you wanna, here's one that startups run into all the time, right? If, let's say, you wanna go and like raise money from investors and you have a friend who knows a lot of rich people, and that friend says, hey, I'll help you and I'll get you investors, but then you have to pay me a commission. Well, in many countries, if that friend doesn't have a license, it's illegal. They have to be a registered broker-dealer, for example, in the United States. Some places, like the United Kingdom, there's the mere introduction exception, where if they just make an intro and they're not selling the product, they're not selling the company, they don't have access to the pitch, they're just like, oh, hey guys, I'm just introducing you. You can pay them a fee, a success fee. But again, it's very highly regulated. And then other areas of financial services, if any of you are doing any kind of tech or software, or run a company that has to do with like banking, finance, crypto, any of those things, then you're gonna have a lot of regulatory stuff to go through. Does anybody in any of these industries, healthcare, financial services? Great, then I don't have to worry about not having answers to those questions. Take a look in chat. Yes, Pratik, you're in biosciences. So yeah, for biosciences, I'm just gonna tell you, you have to work with advisors and counsel who really understand your industry. It's critical. Like, make sure that you work with lawyers who have worked with bioscience companies before, because regulatory frameworks for that stuff is very complex. Dispute resolution.
Yeah, indeed. We touch upon most of the points over there: regulatory, GDPR, or data privacy, everything over there.
Yeah. Good. All right, handling disputes. Okay, so what happens when you get into a dispute with your co-founder, with your employee, with your consultant, with a customer, with a third-party vendor, etc. Right? There's kind of 4 ways that things go down. One, and this is the best one, and this is where you want to really master the art, is of negotiation. Guys, most things don't go to court. Most things don't get litigated. Most people don't sue, because then you have to spend money, right? Then the parties have to spend money, and they have to spend a lot of time. And then even if you win, then you have to spend the rest of your life trying to collect money from the party that you won against. Like, it's not so easy. And so, learn how to negotiate. If you didn't, if you're having a dispute with a vendor or with a customer or whoever, and they're disputing that, I don't know, you didn't pay your bill on time, or you're disputing that they didn't pay theirs, et cetera, that's why you want to think about contracts. You want to be ready for preparing to deal with human nature, but you also just want to be a good negotiator. And part of being a good negotiator goes back to something that I already mentioned a couple times on this call, which is just be a good communicator, be transparent. Right? So like, one of the things, for example, let's say if you're a startup and you're short on cash and you actually owe money to a vendor, and the vendor starts sending you threatening letters, but you're like, I don't know what to do. Call the vendor and say, listen, I want to pay you. Can I pay you 20% right now just to show you good faith? I have a cash crunch, you're first in line, we're gonna get there, etc. The vendor's gonna calm down and say, okay, because it's not in the vendor's interest to go to court, because then the vendor has to spend money chasing you, right? But if you're silent and you say nothing, then that's what the vendor's gonna do. So be open, be transparent, have good conversations with people, learn how to be a good negotiator, learn how to, make offers. Mediation and arbitration. So that's when you start really involving outside people. So when you have a dispute and you're not able to negotiate it because for whatever reason, right? A lot of people, by the way, are not rational actors. So sometimes what you'll have is you'll try to negotiate what you think is a really great deal for both sides, and the other person is just a jerk. That happens too, right? And so then you have to go to court. So you have mediation, arbitration, and litigation. So you can have these things actually all enumerated in your contract, saying like, if there's a dispute, first the parties will spend 30 days trying to negotiate the dispute, right? If that doesn't work, then we're gonna head to mediation. If that doesn't work, then we'll go to arbitration. Like, there are different things. Mediation is usually done by a judge or a lawyer, but it's non-binding. So you go to a third-party professional, both sides, they explain the situation, etc., and the third-party professional is trying to mediate to basically help you to negotiate. The pro of that, right, is it's non-binding, so if you don't agree with the mediator, whatever. And sometimes it's good to have a third party come in and help resolve a dispute. The con of that is it's non-binding, so like you're kind of also wasting your time if the two parties already have a lot of animosity towards each other, right? And then you have arbitration and you have litigation. So that's it. And answering the question that's here in chat, that's it. Like, those are your two options. And oftentimes this is listed in your contracts you draft and contracts you sign, guys. So that's the other reason why you need to learn this stuff, because you need to understand what you're signing, right? Arbitration means that there's no court, there's no jury, there's none of that. You go in front of an arbitrator. There are formal arbitrators in different places around the world, right? It's a judge, but it's a small room. You go in front of one person, or usually it's maximum 3 people, and both parties present their case, and it's a very kind of shortened way to settle a dispute, but arbitration is binding. The thing about arbitration is that in commercial international disputes, this has become the #1 kind of most common way to do it, because people just want to like work fast, get things done, etc. The con when you agree to arbitration is you give up the right to go before a grand jury and have a big litigation and, explain all the horrible things that the other party has done to you to infringe on your IP or what have you. So it's a business decision. It just really depends. If you have IP that's really important to you, you may want to always just preserve the right to litigate. It's such a case by case basis. I can't really advise on one or the other. I can just say that, again, because we work in an international world these days, arbitration has become more common because it's just so expensive to like fly to another country, right? And go through all these things for a lawsuit, etc. And arbitration is just a much easier way to close things out. But usually in your contracts, you want to at least have something that says negotiation in advance. Even if it doesn't say it in the contract, you can still always negotiate with parties. But that's it. But for example, with IP, if you find that there's a third party that's out there that's like clearly infringing your IP, you would start with a cease and desist letter. You would send them a letter, you're infringing on our IP. This is how much money you've now stolen from us by infringing on that IP. And if the other party's like, okay, well, we're willing to settle with you, then you've finalized everything in negotiation. And if they say, no, we didn't infringe on your IP, you infringed on our IP, then things are gonna get heated and you guys are gonna end up somewhere around here. But these are the 4 ways that disputes are handled. Let's see, what's next here? Let me see how many more slides I have, guys, because we only have a few minutes. So, oh, cool, look at this, it's perfect timing. Awesome. All right, international business considerations, right? We've kind of already talked about this. It just, as you expand globally, unfortunately, we live in a world that we just think of as like one big globalized hub, right? We're all sitting on Zooms all day long, talking to each other, et cetera. And the problem is that regulatory frameworks are not globalized. They're different in every jurisdiction. Sometimes they can be similar, but sometimes there are just like these little variations that make massive differences. And so you'll learn through experience. That's really the best way that I can prepare all of you. The more you do, you know, cross-border expansion and all of that, the more you'll learn about the differences in different regulations of different places. And you know, you learn as you go. It is what it is. IP protection, we already talked about it. And the fact that you have to file in multiple jurisdictions. If you file in one place, it just gives you protection in that particular jurisdiction, not the entire world. So just something to be aware of, but I wouldn't be too worried about it at an early stage of your startup. Case studies, whatever. Here, I think best practices for legal health. Yeah, I mean, get a good lawyer. How do you find a good lawyer? How do you know who is good? I don't know. I have no idea. I mean, sometimes they seem really good, and then eventually you're like, oh my gosh, I can't work with this person anymore. Figure out who answers your questions with clarity, who makes you feel secure and safe, who is very honest and upfront with you with what you actually need and how to save money and not spend crazy money, and who wants to build a relationship with you long term. That's how you find a good lawyer, okay? And then, you know, that's it. And, you know, staying updated on legal changes, regular legal audits, things like that. It's a big, overwhelming world out there. And that's the other reason why it's good to have a good lawyer and to educate yourself on the things that I talked about. You want to have good conversations with your lawyer. You want to have control and command over your documents, but you also, as founders and CEOs with non-legal backgrounds, you don't want to spend your life chasing, you know, looking stuff up on ChatGPT rabbit holes and Google and all of that, trying to understand if, like, you know, the new regulation that came out in EU Parliament, does it, like, don't waste your time with this stuff. There are basics. A good lawyer should be able to walk you through it. You will learn, you'll be fine. And that's it. Any questions?
Now you have the ability to ask anything and also make it like, yeah, with raising hands.
Okay, guys, you have
Yes,
5 minutes.
Pratik.
Go for it.
I have a question about vesting. I mean, we have been building our startup for about 3 years now. I understand every time we raise a fund from a VC or something, they will put a vesting schedule in place, which would be usually, I mean, normally it's about 4 years. Do you think we can have an argument over there that we have been working on this for last 3 years, so some part of our share should be early vested rather than waiting for another 4 year?
Yeah. Yes. You should argue. Push. You know,
Sure.
if you shouldn't, I mean, vesting shouldn't start from zero, right? There should be an amount that's already vested and then it's moving forward. This is a negotiation. Don't be afraid to push. I think it's very, very reasonable. You've already contributed a significant amount. And if you were to leave the company tomorrow, there's value that you're leaving behind that you've already created, and that's how you argue it.
Sure. Thank you.
All right,
Right,
cool.
any more
Here's my
questions?
my experience is usually the second these things end, people think of questions that they're like, I wish I had had the time to ask that. So I am gonna leave my contact information here. Okay. I try to be responsive. I'm a little bit busy, so not all the time. I have 2 emails. This is my Constructor email. This is where you can find my company, Aerocore. You can add me on LinkedIn. My name is Kaita Fischer. It's pretty easy to find me. Follow me there. Keep me posted. And hopefully today's session was very helpful to everyone.
Well, definitely. I think that it's a challenge to make in 90 minutes the overview together with the questions, together with the comments, kind of also, context related comments. So thank you so much. And yeah, well, I'm also sending to our dear participants here the feedback form. So please, 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 I mean, just open it, then think about something. Also, you can actually ask questions there in case you don't want to write separate email, etc., because we will definitely send it over to Katya after that. So yeah, just open the feedback form and then it's very important for us. So let's hear what you thought about this overview as well. Then I think that it's a wrap up. Thank you so much, Katya, for this, these 90 minutes. I've been through several legal check sessions, and this was definitely one of the leading ones with like interaction. And of course, people are shy with sharing their stories or maybe answering some of your questions, but it was very important for us to kind of touch upon all of this overview. So thank you so much, and wishing everyone a nice afternoon, day, morning, rest of the week, and a nice weekend as well. Thank you, everyone.
Thank you all so much. Bye.